I will start with a brief overview of the procedural background of this evaluation. On 8 July of this year, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. On July 11, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you submitted your ethics questionnaire on July 4th. The Commission sent you a first round of questions on 1 August 2022. This round of questions included 12 questions with 36 sub-questions, 14 of which requested documents from you. You replied within the requested time period on 5 August. You answered most of the questions except for 2 issues. Namely, you did not explain 2 subparts and did not produce corresponding documents. On 14 September 2022, the Commission sent you the second round of questions that included 15 questions with 29 sub-questions, 8 of which requested documents from you. You replied within the requested time period on 17 September, and you answered most of the questions and produced most of the documents. You did not explain and produce corresponding documents in relation with 4 issues. On 27 September 2022, the Commission sent you the third round of questions. This round of questions included 2 questions with 8 sub-questions, 4 of which requested documents from you. You replied again within the requested time period on 29 September and answered to all the questions and produced the documents in response to all of the requests. Please be advised that under Article 3, Paragraph 4 of our evaluation rules, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless, of course, the candidate provides sufficient justification for not providing the information as requested. I will now turn the hearing over to Nonna Tsutsuriya to commence the questioning for you. Nonna, you have the floor.
Thank you. Greetings, Judge Bejenaru. My first question concerns the plot of land acquired free of charge in Dorlești city. In 2007, based on your request to improve your living conditions, you obtained free from the state a 0.0 hectare plot of land for construction in Chișinău, Dorlești city. You argued that the necessity to improve your living conditions was based on the fact that the total living space of your 70.9 square meter apartment, which had a 41.0 square meter living space located in Chișinău, was insufficient for the 4 people who then resided at that address. The law enforced when you requested improvement of your living conditions stipulated that the public authority could improve living condition of judges only in the form of an apartment or a house. The law did not indicate the possibility to obtain a plot of land for construction. When the Commission asked you why you had petitioned the Dorlești City Council with the request to improve your living conditions and not the Chișinău Municipal Council, since you were the acting judge at the Chișinău Court Bucani office, you explained that you had initially submitted an application for the improvement of the housing conditions at the Prefect of Bucani District, Chișinău Municipality, but that due to the impossibility of granting housing space, the Prefect of Bucani District suggested you that you apply to the Dorlești City Council, which is a territorial administrative unit of Chișinău Municipality. In 2016, you sold this plot of land for a profit of 300,000 leis. For 9 years between 2007 and 2016, you and your family continued to live in the same apartment with 41.3 square meter living space that you had claimed needed improvement. At no time between 2007 and 2016 did you undertake any construction efforts on the plot of land, obtain any permits, or otherwise undertake to build a house. When asked by the Commission whether you had undertaken any construction efforts on this plot of land, you stated that you had not taken any construction efforts because the validity of permissive acts was for only 12 months and you did not have sufficient financial means to construct a house. According to the law then in force regarding the authorization for construction works, an urban planning certificate is valid for 24 months from the date of issuance of the certificate and can be further extended up to 12 months. During the period of 2007 and 2015, you and your wife had total income of over 3.7 million leis. When asked by the Commission whether it was ethical for you to request the improvement of living conditions and to receive a plot of land for construction without the law providing such possibilities, and taking into account the fact that you never lived or constructed anything on this plot of land, and that you then sold this plot of land 9 years later for a profit of 300,000 leis, you explained that it was your moral obligation towards your family to provide it with adequate housing space. You further stated that although the provisions of the law did not directly provide for the possibility of receiving a plot of land instead of an apartment or house, the law did not prohibit the possibility for you to request a plot of land. You stated that it was at the discretion of the Durlești City Council to allocate you a plot of land for free and that, I quote, they were entitled to reject my claim if they considered it to be an unfounded one, end of the quote. You also stated that from the moment you inherited half the shares in your parents' property in Chișinău and thus become a co-owner and were then be able to improve your living conditions, the necessity to construct a house in Durlești City along with continuing to own this land had disappeared and that you had paid the respective taxes. A criminal case was initiated concerning the alleged falsification of the Durlești City Council decision number 424 of 2nd October 2007 and annexes to this decision by which 114 people, including yourself, received authentication titles of the rights over the land plots belonging to the local public authority. This criminal case is currently pending before the Chișinău Court of Appeal. A criminal case was also initiated in relation to the daughter of the former mayor of Durlești City with regard to the fraudulent alienation of several land plots in Durlești City. When you were asked by the Commission about these criminal proceedings, you explained that you did not have any legal standing in these proceedings. I'll begin by asking you some questions to establish the facts. Hopefully this can be answered with a yes or no response. And later I will ask some questions that will seek greater detail or explanation from you. Please confirm that in 2007, by decision number 424 of 2nd October 2007 of the Durlești City Council, you obtained a 0.06 hectare plot of land from the state for free.
Yes, I confirm.
Please confirm that at that time you were living in Chișinău in the 70.9 square meter apartment which had a 41.3 square meter living space area that was owned by you, your wife, your son and your mother.
Yes.
Please confirm that at that time, 4 people had permanent residency registered at that address.
Da, confirm.
Yes, I confirm.
Please confirm that in 2007 you were working as a judge at the Chisinau Court Bucani office.
Da,
Yes.
Please confirm that you applied to Durlesti City Council with the request to improve your living conditions based on the provisions of Article 30 of Law Number 544 of 1995 and taking into account the lack of 15 square meter living surface for each person registered in this 70.9 square meter apartment.
da, confirm.
Yes, I confirm.
Please confirm that when asked by the Commission why you applied for housing from the Durlesti City Council rather than in Chisinau municipality, since you were the acting judge in Bucani office of Chisinau Court, you informed the Commission that you first applied to the Chisinau Municipal Council, which directed you to Durlesti City Council due to the impossibility of providing housing space in Chisinau municipality.
Da,
Yes.
Please confirm that Law Number 544 of 1995 provided for the possibility of a judge to request the improvement of living conditions only by receiving housing in the form of an apartment or house.
da, confirm.
Yes, I confirm.
Please confirm that this law did not provide for the possibility for a judge to receive a plot of land for construction.
Da, legea nu prevede.
Yes, the law didn't provide it for land.
Please confirm that the criminal case was initiated on the fact of the alleged falsification of the decision of Durlesti City Council number 424 of 2nd October 2027, by which you had obtained a plot of land.
Da,
Yes.
Please confirm that the criminal investigation was instituted against the daughter of the former mayor of Durlesti City Council with regards to the fraudulent alienation of several land plots in Durlesti City.
eu sunt la curent, dar nu știu
I am
fiecare
aware of
sau
it,
nu fiecare,
but I'm
pentru
not
că
certain whether it was the daughter or not. I know there is a criminal file.
Please confirm that you neither in the past or currently have any legal standing in these criminal proceedings.
Nu, n-am fost citat
No, I
niciodată.
wasn't summoned.
Please confirm that you sold the plot of land in 2016, 9 years after you first received it for 300,000 leis.
Da, confirm.
Yes, I confirm.
Please confirm that you and your family continued to live in the same 70.9 square apartment in Chisinau 9 years after receiving the plot of land for free from the state.
Da,
Yes.
Please confirm that you did not construct anything on this plot of land or ever lived there.
da, confirm.
Yes, I confirm.
Please confirm that you did not undertake any efforts to construct or build anything on this plot of land and that you informed the Commission that this was because of the permissive acts were valid for only 12 months and you had insufficient financial means to build the house.
Confirm.
I confirm.
Please confirm that the provision of law number 163 of 2010 regarding the authorization of the execution of construction works provided you the possibility to obtain the urban certificate planning valid up to 36 months.
Da, legea prevede.
Yes, the law provides for that.
Please confirm that during 2007 and 2015, you and your wife had total income of over 3.7 million leis.
Posibil. Că nu-
That is possible.
N-am făcut totalurile, dar
We did not
confirm că
sum
e
it up,
posibil,
but
dacă
I
ne-am
confirm that
declarat
there is
așa e.
this likelihood if that's what we declared.
Please confirm that when you were asked whether it had been ethical for you to request the improvement of your living conditions and receive the plot of land for construction without the law giving you such a possibility, You told the Commission that it was your moral obligation to provide your family with adequate housing.
Da, așa.
Yes, that's the answer that I gave.
Please confirm that you also told the Commission that although the provisions of the law did not directly provide for the possibility of receiving a plot of land instead of an apartment or house, the law did not prohibit the possibility to request a plot of land.
Da, confirm.
I confirm.
Please confirm that you also told the Commission that it was at the discretion of the Durlesti City Council to allocate you a plot of land for free, and you stated that, I quote, they were entitled to reject my claim if they considered it to be an unfounded one, end of the quote. Please confirm that when you were asked by the Commission whether or not it was ethical for you and your family never to have lived or constructed anything on the plot of land, and that you then sold it 9 years later for a profit of 300,000 leis, you told the Commission that the need to construct a house in Durlesti city and continued ownership of the land plot disappeared when you inherited half the shares in your parents' property in Chisinau and the living conditions were improved. You also indicated that you paid the respective taxes.
Da.
Yes.
And lastly, do you have anything to add or further clarify with respect to this issue?
Da.
Yes.
Vreau să adaug
I would like to
fiindcă,
add
într-adevăr, legea
that indeed the
la
law
acel moment,
at that time,
544, prevedea
544 that is,
alocarea
that law provided at the time
ca
the
îmbunătățirea condițiilor
allocation
de trai
for
a
improving of housing conditions,
apartamentului
allocation
sau
of
a
an
unei case.
apartment or of a house.
Dar vreau să
However,
atrag
I
atenția
would
că
like to highlight
norma dată,
that as far as that
alocarea unei
provision is
case
concerned, the
este o
allocation, the
normă
attribution
desuet.
of a building
sau mai bine zis, o
is
normă moartă, pentru că
rather
din câte
outdated
eu
or
cunosc niciodată,
not
niciun
applicable is in,
judecător
as
nu
far
a
as
fost-
I know,
au-
for
nu
no
au fost
judge
alocate,
have
cuiva casă în baza acestei
been
legi.
given houses on the basis of this law.
Organele locale
The local
acordau
authorities
numai apartament,
would only
dacă
give an
era
apartment
posibilitate.
if there was this
Dar
possibility.
casă nici vorbă nu putea să
However,
fie la
a
acel
house
moment,
that
dar
was
nici-
never something to be actually implemented, and that's why I applied for that, at the suggestion of local authorities too, because at that time there were many decisions that hadn't been enforced with decisions with regards to the appropriation of leaving of housing to public servants. And there was no possibility to give them the housing space, and that's why the authorities suggested that if you want to, you could apply for or request land, a plot of land. With regards to building something on this plot of land, I would like to say that indeed I did not have the required financial resources to initiate any building, any construction, but in 2010 I fell ill with a severe disease and I had to undergo surgery abroad. And the amounts that I used to accumulate for a house, I had to spend my savings for healthcare services. For that reason, I never had the possibility to actually initiate any construction of a house on that land plot. And indeed, the law 544 does not provide for the appropriation of a land plot for improving housing conditions, but it also doesn't prohibit local authorities to appropriate a land plot if that is possible. And indeed, that was up to the local authorities to either admit, to accept or reject the appropriation of that land plot. With regards to whether it is ethical or non-ethical, I can only add that owning that land plot, I regarded that it was non-ethical to apply for apartments for judges who had the possibility to pay preferential prices. So, particularly because I had this land plot, I did not apply for that, for preferential prices. I know that many of my colleagues had an apartment and nevertheless applied for and received a preferential price apartment. But at the time, I thought it was non-ethical to apply for preferential prices since I already had a land plot. Indeed, I have sold it 9 years later because I no longer had the need to build something on that land plot, and I paid all associated taxes to the tax authorities. Thank you.
Thank you. I'll proceed now with this second question, which concerns ownership of real estate located in Chisinau. According to your 2016 Declaration of Assets and Personal Interests, you obtained through inheritance over 500,000 leis. When asked by the Commission about the inheritance, you told the Commission that this amount represented the value of your share of property inherited in 2016 after the death of your father. The property consisting of 101.5 square meter house and 0.0 hectare plot of land is located in Chisinau. You also told the Commission that your parents had acquired the property in 2008 for the declared price of 1,036,000 leis, and that the funds used to purchase the property was savings and resources accumulated by them over a number of years. You also indicated that the house had been built 40 years ago and required substantial repairs, which took a long time to complete. You claimed that the repair costs were incurred by your parents and you did not make any contribution to this. You did not provide documents regarding the source of the financial means used by your parents for the purchase of this real estate and the payment for the repairs to the house. According to the tax authorities, during the period 1994-2008, your parents obtained gross taxable income of over 34,000 leis. Your parents did not sell any movable or immovable property or declare any other income to the tax office during that period. When asked for information and documentation regarding any employment of your parents and other incomes received by them prior to 2008, it is a time when they bought the house, other what was declared to the tax office, you said that you did not have any concrete information or documents regarding the employment of your parents. You also told the Commission that your parents left their estate in equal parts to all three of their sons. After the death of your father, you and your brothers each received 1/3 of your father's half share of the house and land located in Chisinau. Subsequently, both of your brothers renounced their share of inheritance and transmitted it to you. You provided the Commission declarations of renunciation of succession, by which your brothers gave up the testamentary succession as well as the legal one in your favor. You explained that this renunciation was conditioned by the transmission and assumption of your moral and material responsibility for the care of your mother. As a result, you obtained half a share of the property. After the death of your mother in 2021, you and your brothers each inherited 1/3 of your mother's share of the property. You also informed the Commission that none of the testamentary heirs or their successors officially renounced their inheritance rights within the 3-month period provided by the Civil Code. Therefore, it is considered that all her heirs accepted the inheritance and became the owners of 1/3 of the half share that had belonged to her. At the moment, no documents have been submitted to the notary for the preparation of notary acts on inheritance after the death of your mother. In 2011, your father donated 3 plots of agricultural land, 1 plot of construction land, which included a house with the area 70.7 square meters and 3 auxiliary constructions with the combined value of over 33,000 Moldovan leis to your son. Your son sold 3 agricultural lands in 2011, 15, and 18 for a total price of 62,000 leis. Your son sold a plot of land for construction and 4 constructions in 2021 for a total price of 5,000 euros, equivalent to about 105,000 leis at the exchange rate at that time. Your parents had 3 children and 11 grandchildren. When asked whether your parents donated any property or assets to their other children or grandchildren, you told the Commission that your parents had donated and passed on by inheritance their estate not only to you and your son, but practically in equal parts to all their successors. You informed the Commission that 2 plots of agricultural land with the combined value of 10,000 leis were donated to one of your nephews. You further explained that based on the donation contracts, one of your brothers had become the co-owner of 2 agricultural land plots with the combined value of 10,000 leis. You also indicated that a quarter share of the 70.9 square apartment located in Chisinau, which had previously belonged to you, your wife, your son, and your mother, had since been sold to your nephew, who had also received 2 plots of agricultural land. According to the information available to the Commission, this apartment was sold to your nephew in 2019 for 400 Moldovan leis. I will start with a few questions to establish the facts, and later on you will be given a possibility to provide further explanation. Please confirm that in 2016 you declared 0.5 million as an inheritance received from your father.
Da.
Yes.
Please confirm that when you were asked about the source of the financial means from which your father had donated over 500,000 to you, you informed the Commission that this amount was the value of the share of the property you had inherited in 2016 after the death of your father.
Da, confirm.
Yes, I confirm.
Please confirm that this property consists of 101.5 square meter house and a 0.06 hectare plot of land in Chisinau.
Da, confirm.
Yes, I confirm.
Please confirm that you informed the Commission that your parents bought this house and the plot of land in 2008, and that the declared price of the property was 1,036,000 Moldovan leis.
Da, confirm.
Yes, I confirm.
Please confirm that you informed the Commission that the house was built 40 years earlier and that it required substantial repairs, which took a long time to complete after the property was purchased.
Da, confirm.
Yes, I confirm.
Please confirm that all the repair costs were incurred exclusively by your parents.
Da, confirm.
Yes, I confirm.
Please confirm that during the period 1994-2008, your parents obtained gross taxable income of 34,000 Moldovan leis.
Eu nu cunosc asta.
I have no knowledge of it. If that's what I found out about it from the data that I received from the Commission, so I confirm.
Please confirm that when you were asked about the source of income used by your parents to purchase this real estate and pay for the repairs to the house, you told the Commission that you did not have concrete information or documents.
Da, confirm.
Yes, I confirm.
Please confirm that you told the Commission that this real estate was the only property your parents had bought during their lifetime.
Da, confirm.
I confirm.
Please confirm that in 2011, your father donated 3 plots of agricultural land, 1 plot of construction land, which included a house with an area of 70.7 square meter and three auxiliary constructions with a combined value of 33,000 leis to your son.
Da, confirm.
I confirm.
Please confirm that 3 agricultural lands your son was given in 2011 by your father were sold in 2011, 2015, and 2018 for a total price of 62,000 leis.
Confirm.
I confirm.
Please confirm that the land for construction and for constructions that your son was given by your father in 2011 were sold in 2021 for a total price of 5,000 euros, which is equivalent to approximately 104,000 Moldovan lei.
Da.
Yes.
Please confirm that your father left from his estate in equal parts to all 3 of his sons a 1/3 share of the house and the land located in Chișinău.
Da.
Yes.
Please confirm that your mother left from her estate in equal parts to all 3 of her sons a 1/3 share of the house and the land located in Chișinău.
Da, confirm.
Yes, I confirm.
Please confirm that your brothers gave up their testamentary succession as well as the legal one in your favor after the death of your father.
Da, confirm.
I confirm.
Please confirm that to date, none of the testamentary heirs or their successors renounced their share of inheritance after the death of your mother.
Da, confirm.
I confirm.
Please confirm that after the death of your mother, no documents have yet been submitted to the notary for preparation of the notary acts on the inheritance.
Da.
Yes.
Please confirm that after the death of your mother, none of the testamentary heirs or their successors have yet registered their share in the cadastre.
Da.
Yes.
Please confirm that your parents had 3 children and 11 grandchildren.
Da.
Yes.
Please confirm that when asked whether your parents had donated any property or assets to their other children or grandchildren, you told the Commission that your parents had donated and passed on by the inheritance their estate in equal parts to all their successors.
Da.
Yes.
Please confirm that you informed the Commission that one of your brothers became the co-owner of 2 plots of agricultural land with a combined value of 10,000 leis.
Da.
Yes.
Please confirm that you informed the Commission that one of your nephews became the co-owner of 2 plots of agricultural land with the combined value of 10,000 leis.
Da.
Yes.
Please confirm that 70.9 square meter apartment located in Chișinău, which had belonged to you, your wife, your son, and your mother, was sold to your nephew in 2019 for 400,000 leis.
Da.
Yes.
Please confirm that you informed the Commission that the nephew who purchased the 70.9 square meter apartment in Chișinău also received 2 plots of agricultural land from his grandparents.
Yes.
And finally, do you have anything to add or further clarify with respect to this issue? Floor is yours.
Da, mulțumesc.
Yes. Thank you.
Aș vrea să accentuez aici că,
I would like to highlight that indeed the house that was purchased by my parents in 2008 was built in 1966, and it's 105 square meters, and only 50 square meters belong to me.
Am răspuns
And I've answered to the Commission that indeed I did not know about the sources of the funds that my parents used to pay for the house. And I can say that I am not aware. I mean, back in the time my brother has purchased a house, and I also don't know what were the sources that he used. And therefore, I did not get involved into, I did not look into what were the sources, where they took the money from. The fact that with the tax authorities, you found that there's only that particular amount that you communicated, I can say that that is the official amounts earned by my parents, so that was declared with the tax authorities. What is more, during 14 years, none of the relevant authorities took any actions with regards to the lawfulness of the procurement or the sources that supported the purchase of that house. With regards to the inheritance that was left by my parents, I would like to confirm that both of my parents have written a will where they left property to all three brothers. And the land plots that they owned were sold, to everyone, one directly to a brother and two other land plots to the grandchildren, to my son and to the son of my elder brother. And they were equally donated to all. And after my mother passed away, indeed none of the brothers rejected or refused the inheritance. We did not go to the notary to secure the inheritance because one of our brothers is in France and is there for a long time now, and so he's not in Moldova. And as soon as he's back, we will clarify all matters regarding to the inheritance left by our mother. I think that is all that I wanted to add.
If I may clarify one issue, you mentioned that one of your brothers contributed to purchase of the partner house in 2008. Do I understand it correctly, or if you could clarify this, please?
No, not in 2008. At some point later, in about 2012, he bought a house in Râșcani, in the town of Râșcani. And that was some time later. He works in the field of construction, so I know that he would also help our parents with renovating their house in Chișinău. So when he'd return from abroad, from what I know, he'd also do some renovations at the house.
Thank you. I'm done, Mr. Chairman.
Very good. Before we pass on to Vitaly, I think we would like to close the windows, if that is, just reduce the noise a bit. Does it work as yet? Okay. All close? Okay, very good. Vitaly, go ahead.
Thank you, Chairperson. Mr. Bejenaru, I would also like to greet you. In the context of continuing the procedure studied by my colleagues, I would like to also ask you some questions about some topics. I hope the questions asked could take a yes or no answer. So let's take the context. In the Declaration of Wealth, Assets and Personal Interest of 2019, your son declared 60,000 euros and $21,208 received as wedding gifts and 40,000 euros received in gifts for the christening of his child. When asked by the Commission about the costs or expenses incurred by your family for these ceremonies, you explained that you paid 10,150 150 lei to book the wedding hall and 303,144 lei for cash for restaurant services. You also paid 4,000 euros, 83,006 lei, according to the exchange rate, to a studio for organizing the wedding ceremony. You did not declare these donations of 303,000 lei and 4,000 euros in your 2018 declaration. You only declared them in your 5-year declaration sent to the Commission, specifying that as contributions to your son's wedding, but you indicated that you did not incur any expenses for the christening ceremony. So please confirm that in 2019 your son declared 60,000 euros and $21,208 as donations received in wedding gifts and 40,000 euros received in gifts for the christening of his child.
Da.
Please confirm that you paid 10,150 lei for booking the wedding hall. Yes, I confirm. Please confirm you paid 303,142 lei in cash for restaurant services. Yes, I confirm. Please confirm that you paid 4,000 euros cash to a studio for organizing the wedding ceremony. I confirm. Please explain if you made any cash donations to your son or your son's family for the wedding that were not related to the expenses for this event. If so, how much? Donation additional to these amounts, you mean, da? Yes? Yes. Maybe I can elaborate a little bit so that you understand the context of this question. There are donations that some, like the gifts, as we say, the gift that you put on the table. Did you give anything additional? No, that was our contribution to organizing the ceremony. Please confirm that you did not declare in the 2018 declaration the amount of 303,142 lei and 4,000 euros. I don't remember. I probably did not. You are not sure, or if you mentioned, or I mean, do you disagree, or I'm not sure. As far as I remember, I did not mention this in the declaration. So you confirm it? Yes. Please confirm that you declared in the 5-year declaration the amount of 303,142 lei and 4,000 euros as contributions to your son's wedding. In the declaration to the Commission? Yes, I did. Please explain if by contribution you meant donation. If not, what's the difference? Come again, I did not understand the question. Previously, you said that this money used to organize the event was provided as a donation. No, please, I just want to finish my question. In the declaration you submitted to the Commission, you qualify them as contribution. And we would like to understand what's the difference between these two definitions. I believe that these amounts were parents' contribution to organizing the ceremony. They were not donated directly to my son. These were expenses we incurred to organize the ceremony. And I perceive this as a contribution to organizing the ceremony. It's not a direct donation, as like we later on donated money for another apartment. Please confirm that you did not incur or reimburse any expenses for the christening ceremony. I confirm.
Pornind de la răspunsul anterior,
Based on your previous answer,
faptul că n-ați suportat
and the fact that you did not incur any expenses related to the christening ceremony, did
did
you make any donation to your grandchild in relation to this event? If yes, what was the amount of donation?
Sume nu, fiindcă noi am dat,
Not
am
amount,
adunat
because
mai
we
mult cadouri.
brought several gifts.
Concret, sume nu țin
I don't remember the specific amount at the
Spuneți că ați făcut
christening
cadouri,
party.
nu
So you say you
copii.
made gifts to
Da,
your
cadouri
grandchild?
din
Yes.
obiecte.
Gifts in terms of objects or things. Could you elaborate, please, what gifts exactly, how valuable, so that we could have an impression of that?
Haine, cărucior,
Some clothes, a stroller, I don't remember exactly the amounts.
Orientativ
Give or take?
sau un calcul cert dacă îl aveți?
Or maybe you have a specific, a clear calculation?
pot să vă spun.
No,
Ceva,
I cannot
câteva
say.
mii de lei, ceva, nu,
Some thousand lei, probably.
nu mi-am pus în scop să memorizez.
I never intended to remember it by heart.
Doriți să oferiți careva alte explicații pe marginea subiectului abordat?
Would you like to provide any other explanations on this topic?
Mai pot să adaug faptul
I
că
could add that
am un singur ficior și
I have
ca
only one
părinte noi
son,
am
and as a parent,
hotărât să-i organizăm o
as
nuntă.
parents,
De
we
aceea am
decided to organize his wedding.
suportat aceste
That's why
cheltuieli
we
ca părinți.
incurred these expenses as
ceremonie de
parents for his wedding party.
Un alt subiect. pe
Another
emisiunea
topic,
noastră.
if you don't
În anul
mind.
2017, soția
In
dumneavoastră a
2017,
donat
your
fiului
wife donated to
suma
your
de 280
son
lei.
the
În
amount
anul
of
2018, soția
280,000
dumneavoastră a donat
lei.
fiului
In 2018, your
suma
wife donated to the son 196,157
Ați prezentat
lei.
comisiei două contracte
You
pentru
provided
aceste
two donation
donații.
contracts to the Commission.
Dumneavoastră nu ați raportat
You
aceste
did not
donații în
declare these
declarațiile
donations in
de avere
your
și interes
declarations of
pentru
assets and
anii
personal interests for the
2017
years
și 2018.
2017 and 2018.
În răspunsurile pe care le-ați
In your
dat
answers to the
comisiei,
Commission,
ați recunoscut
you
că ați
acknowledged that
neintenționat să declarați
you
donațiile
had
făcute de
unintentionally
soția dumneavoastră
omitted
în
to declare
declarațiile de
donations made by
interes
your
personal
wife
pentru anii nominalizați.
for the years 2017 and
De asemenea, ați afirmat că
2018.
fiul
You also
dumneavoastră a
stated that
declarat
your son
aceste sume în declarația sa
had
de avere
declared
și
these
interes
amounts in
personal
his
în
declaration of
calitatea sa de
wealth and personal
funcționar
interest
public.
as a civil servant.
Vă rugăm să confirmați că în anul 2017
So please confirm
soția
that in
dumneavoastră a donat
2017
fiului
your
său
wife
suma de
donated to your
280.000
son
de lei.
the amount of 280,000 lei. I confirm.
Vă rugăm să confirmați că în
Please
anul
confirm that in
2018 soția
2018
dumneavoastră a
your
donat
wife
fiului
donated
său
the
o sumă
amount
de
of
196.157
196,157
lei.
lei to your son. Yes.
Vă rugăm să confirmați că nu
Please
ați raportat
confirm
aceste
that
donații
you
în
did
declarațiile
not
dumneavoastră de avere și interes
declare
personal
these
pentru
donations in
anul
your declarations
2017.
for 2017 and
Confirm că a
2018.
fost omis
I
declararea.
confirm I omitted that from the declarations.
Pornind de la faptul că recunoașteți această
Well,
omisiune,
based on the fact that you
puteți să ne comunicați
acknowledged
când ați
this
realizat
omission,
că
could you
e
please tell
această
us, when did you
omisiune
realize
fost
that
comisă?
this omission took place?
Înțelegeți? Asta a fost prima
Do you understand?
donație
This
noastră
was
care
our
noi am donat
first
fiului și
donation
până atunci în fiecare
to our son.
declarație
Until
de venit,
then, in
noi
every
declaram
declaration
numai
of
veniturile
income, we
care
were
le aveam.
only declaring the
Și
income that we
niciodată
had,
nu m-am,
and we never thought.
a fost omis problema de declarate anume și
We
donații.
just
Am depistat
omitted
anume
these
atunci
donations.
deja
We
când
found
comisia
it
ne-a pus
only when
întrebările,
the Commission asked the
referitor la
questions
donațiile astea,
about these
atunci ne-am,
donations. Then we, and only then we realized
am înțeles că am fost omis
that,
anume declararea contractelor acestea de
these
donații.
donation
Să fiu
contracts
sigur în răspunsul
were omitted.
dumneavoastră,
To be certain of your answer, you realized this deviation when you received questions from the Commission. Yes,
Contractele
because
acestea de donații
these
au
donation
fost
contracts
declarate de
were
ficior în
declared by
declarațiile
my
lui
son
și
in
nu
his
trasă de
declarations,
că
and we did
nu
not think
trebuia noi să le declarăm.
that we had to declare
ați
them too.
întreprins careva acțiuni când ați aflat
Did
despre
you
această
take any
eroare?
action when
Dacă
you
da,
found
ce acțiuni au fost
about this error? If yes, what action?
N-am întreprins deja.
I
fiindcă
didn't take any
perioada
action
îndelungată
because
a expirat și nu
this
știam
was a long
ce
time ago and I didn't know what to do,
cum putem corecta.
how we can correct this.
Doriți să oferiți careva alte explicații pe
Is
marginea
there anything
acestui
further you
subiect?
would like to explain?
Nu, nu știu.
No, no, thank you.
Următorul subiect va fi
The
despre
next
conturile bancare,
topic is about bank
respectiv
accounts.
contextul.
So let's see the
Dumneavoastră
context.
ați avut un cont bancar
You
la
had a
Victoria
bank
Bank deschis în
account opened at
2011 și
Victoria
închis
Bank in
în anul
2011 and closed in
2019. În perioada
2019.
anilor 2011 și 2013,
During 2011 to
pe
2013,
acest cont au fost depuși 5
um,
milioane de euro.
at 5,100 euros were deposited into this account. You did not declare this account in your annual declaration for 2012. In your answers to the Commission, you declared that this account was a current account for personal needs, including travel or holidays abroad. You also explained that you regularly deposited the amounts into this account. Moreover, you said that you did not declare this bank account because you did not have it for a long time and you are not using it anymore. Before 2016, the law required that subjects of declaration were to declare all bank accounts they had regardless of the balance on them. So please confirm that you had a bank account at the aforementioned bank, opened in 2011 and closed in 2019. I confirm. Please confirm that you regularly deposited money into this account during the years 2011 to 2013, a total of 5,100 euros. Yes. Please confirm that you did not declare this bank account in your annual declaration for 2012.
Da, confirm pentru
I
2012 a
confirm
fost
for
declarat
2012.
anii ulterior, fiindcă a
It
fost
was
omis
declared
anul acesta.
later because it was omitted in that year. Please explain why you did not declare that bank account in your annual declaration for 2012.
Cum am spus, asta a
As I
fost o
said,
misiune,
it was
fiindcă
an omission
având
because
mai multe conturi,
having several
erau
accounts,
ceva, nu mai țineam curentul la toate și au fost
wasn't
omise. Și nu numai acest cont, dar
keeping
mai
up to date with all of them, and I omitted, well, I just missed it because there were several accounts. I used some of them, did not use some others. It was, I just missed it. It wasn't intentional or something. Well, since it was an omission, when did you realize this error?
De asemenea, în momentul când am primit informații
Also,
de la
when I
Comisie,
received
deoarece
information from the
ulterior el era
Commission,
declarat
because
și n-am-
later on it has been
n-am dat seama
declared,
că
and
atunci
I
am
did
fost
not
omis.
know that in 2012 I missed declaring it.
Similar, mă întreb dacă au fost întreprinse
Similarly,
careva acțiuni în
I
vederea
need to ask,
remedierii
did you
situației
take any action to remedy the situation?
N-am întreprins, deoarece
No,
era deja
Because
declarat
again,
ulterior.
it was declared
Ceva
subsequently.
suplimentar pe marginea subiectului
Would you like to say anything
abordat,
further about this
aveți
topic?
poate careva explicații
Maybe some
suplimentare?
additional explanation?
Nu, în afară de ce,
No,
într-adevăr, a fost
only the
omis
fact
într-un
that
an să-l declară,
It was just one year when I omitted to declare it, and then starting next year I started to declare it.
În același context, practic.
Almost in the same context. According to the information available to the Commission, your wife had a bank account opened at Mobiles Banca in 2010, closed in 2016. You did not declare this bank account in your declarations for the years 2012 to 2015. In your answers to the Commission, you explained that this bank account was not used within the indicated period. Before 2016, the law in force required the subject of declaration to declare all bank accounts regardless of the balance. Please confirm that your wife had a bank account at the aforementioned bank opened in 2010 and closed in 2016.
Da, confirm.
Yes, I confirm. Please confirm that you did not declare this bank account in your annual declarations for the years 2012, 2013, 2014, and 2015.
Da, confirm.
Yes, I confirm. Please explain why you have not declared this bank account in your annual declarations for the mentioned years.
Cred că e același motiv. Deținând
The
mai
reason
multe
probably is
conturi
the
bancare
same, having
de
several
serviciu,
bank
că sunt
accounts,
este, și eu și
job-related,
soția nu
personal,
am
both
omis
me and my wife,
declararea lui în
just
acești
missed
ani.
declaring it during those years.
O întrebare care se repetă, dar când ați
Repeated
realizat că
question.
au fost
When did
comise
you
eroare
realize that you had made this error
legat de anume acest cont bancar?
regarding this specific
Tot
bank
acum,
account?
la
Also now,
informația
when
Comisiei.
receiving information from the Commission.
Careva acțiuni privind remedierea?
Did you take any action to remedy it? No.
Ceva suplimentar,
Would you like
explicații pe marginea
to provide any
subiectului
additional
acordat,
explanation about this topic?
dezbătut, de fapt, pardon.
About the topic we debate? No, I don't have any.
Și ultimul subiect care aș
And
dori să-l discut
the
cu
last
dumneavoastră.
subject I'd like to discuss with
Conform
you.
informațiilor ce stau la dispoziția Comisiei,
According to the
soția
information
dumneavoastră a
available
avut
for
un
the
cont
Commission,
bancar
your
deschis la
wife had a
Victoria
bank
Bank în
account
2006.
opened at
Nu
Victoria
ați
Bank
declarat acest cont
in
bancar în declarația
2006.
dumneavoastră pentru
You
anul
did not
2012.
declare
În
this bank
răspunsurile
account in
către
your
Comisie
declaration for
ați explicat că ați omis
2012.
declararea acestui
In your
cont
answers to
bancar
the
în
Commission, you
declarația
explained that you omitted to
2012.
declare this bank account in your declaration for 2012.
Respectiv, legea prevedea expres
But the law
că
required
până în
expressly that until
2016
the subjects of declaration had to declare all their bank accounts regardless of the balance. So please confirm that your wife had a bank account at the aforementioned bank, opened in 2006. I confirm. Please confirm that you did not declare this bank account in your 2012 declaration. I confirm.
Care a fost motivul nedeclarării?
What was the reason of not declaring it?
Consider că același
I
motiv
believe
a
the
fost
reason was the same.
omis,
It was omitted
neintenționat de
unintentionally.
a-l declara.
Ați realizat această omitere?
Did you realize that it was missing?
În răspunsurile dumneavoastră,
In your answers,
insistați că ați omis acest...
you keep saying that you omitted mentioning it, which means that somewhere at some point you realized that there is a deviation. When did you become aware of making this omission?
Faptul că n-a fost declarat în
The fact that it
2012,
wasn't
eu am
declared in
aflat acum de la comisie,
2012,
dar
I just
faptul
found
că
it
el în
about it from the
2013,
Commission.
următorul a fost
But
declarat,
starting in 2013, it was
confirmă că nu a
declared.
fost
This means that
intenționat.
this was not unintentionally. And we had several accounts, salary account, my wife, there was a change in the banks that were providing salary. Maybe it hasn't been closed by that time, and I just omitted to mention it. I just don't want to ask the same question 3 times, but I have to do it because it's important for the Commission to understand. Did you take any action in order to remedy this error when you became aware that you omitted it in your declarations? No, I didn't undertake any action because the declaration was omitted in 2012, and I can't correct this mistake. Do you have any additional aspects, explanations about this topic, please? No. Mr. Bejenaru, I thank you for your answers. Mr. Chairperson, I have no more questions.
Okay, thank you, Vitali, and I will continue with the following topic that relates to cars. Between 2008 and 2011, you held the right of usufruct over a BMW 7 Series car from the model year 2004. During this period, the owner of the vehicle was a close relative. In 2011, you purchased this vehicle for the declared price of 110,000 lei, which was equivalent to about 6,700 euros. And you sold this car in 2013, 2 years later, for the declared price of 150,000 lei. So that is 40,000 lei more than the purchase price 2 years before. You provided the sales purchase contract for this car to the Commission, and you did not pay tax on the capital increase of 40,000 lei. In your 2013 tax form, submitted for the purpose of calculating the increase or decrease of the capital, you indicated that the purchase price of this car was 240,000 lei. In your answers to the Commission, you indicated that you had actually made an error when informing the tax services that the declared purchase value of the car was 240,000. You explained this by stating that on the very same day as you sold the 2004 BMW 7 Series, you purchased another car, also a BMW 7 Series from 2008, for that price of 240,000 lei. You stated that the correct price should have been 110,000 lei. However, you still had the obligation to pay tax on capital increase from the sum of 40,000 lei from the sale of the car in accordance with provisions of the fiscal code. Now here are a couple of questions, first of a factual nature. Please confirm that you held the right of usufruct over the 2004 BMW 7 Series between 2008 and 2011. Okay. Please explain why your relative allowed you to use the car for free for 3 years.
I answered this question in the questions you had before. This relative had a service car, a job car. He allowed me to use this car as needed. It wasn't always available to me, but when needed, I had the possibility to use this car.
Okay, thank you. Please confirm that you purchased this car in 2011 for the declared price of 110,000 lei.
Yes, I confirm.
And please confirm that you sold this car in 2013 for the declared price of 150,000 lei, so to say 40,000 lei more than the purchase price.
Yes, since I declared it, I confirm it. I don't remember it by heart, but I confirm.
Okay. Please explain how you were able to sell this car 3 years later for 40,000 lei more than the purchase price 3 years before.
I can explain here that the car was in a good condition. I also repaired it. I don't remember exactly. But it was a bilateral transaction with the buyer, so we reached a price that was agreed on by both sides.
Okay. And please confirm that you did not pay any tax on the capital increase from the difference in price of the 40,000 lei.
I can confirm that every year I filed my return to the tax authority and I paid the tax mentioned by the tax authority. I cannot confirm whether I was supposed to pay or not. So what I was, the tax authority were giving me information on how much I was supposed. Maybe if it wasn't included there, I didn't pay it.
But did you mention that you sold that car in that year in your tax declaration?
Yes, of course. I declared that I sold the car, at what price. This was the tax declaration, which I was filing every year to the tax authority. And the tax authority were calculating the income tax I was supposed to pay.
Okay. Please confirm that in your 2013 tax form, you declared that the purchase price of this car was 240,000.
Yes.
Okay. And please confirm that when the Commission asked what the real purchase price of this car was, the 110,000 instead of the 240,000, you answered that you'd made an error in your 2013 tax form and that the purchase price of the car was in fact 110,000.
So, as I said, on the very same day, I sold a car for 110 and I purchased another car. That's why there was this difference. I mean, it's not a difference that I sold it for 110 and wrote or reported 240. It's just two cars. One was sold and one was purchased on the same day in 2013. And I declared both contracts to the tax authority, one for selling one car and another one for buying a car.
But in that year, the selling price was 150,000, not 110,000.
Eu nu știu, asta a fost un contract
I
bilateral
don't know if it was
de,
a bilateral
între părți. Eu nu pot
contract
să
between
spun
the
cât era
parties.
precis.
I
Eu am
don't
indicat
remember
anume
the
prețul
price.
care
I
a fost realizat
reported the
automobil.
price for which I sold the car.
Okay. And when did you realize that you made an error, actually, in relation to those figures?
În cifrele date am înțeles că
I
e
realized
eroarea,
there
nume
is an
când
error
am
in these
primit
figures
de la
when I
comisie întrebările
received
și
the
am
questions from the
constat că,
Commission, and I found that
la fisc a fost greșeală,
there
ne-au
was
indicat diferite prețuri.
a mistake in what was in the data from the tax authority with the different prices for the car.
Okay. And when did you take any action when you found out that there was an error made at that time?
Nu,
No.
n-am întreprins.
No, I haven't.
Okay. Anything else to add to this particular issue?
No.
Then, going on from 2013, as we stated, you purchased another BMW 7 Series this year, this time from the year 2008, for the declared price of 240,000. In 2016, you sold this car for the price of 290,000. So 3 years later, the price of selling was 50,000 more than the price of buying in 2013. You provided a sales purchase contract for this car to the Commission, and according to your 2016 tax form, you paid tax on the capital increase from the sale of this car. Now, 9 years later, in this year, in 2022, such cars are on sale for the price of 14,000 euros, which is roughly the same price as what you purchased it for 9 years ago. When asked to explain the difference between the market value of the BMW 7 Series and the declared value of the car in 2013, you stated that the price was subject to direct negotiations between the parties of the contract. Again, a few factual questions to get started. Please confirm that you purchased the 2008 model BMW 7 Series in 2013.
Da, confirm.
And
Confirm.
please confirm that the declared purchase price at the time was 240,000 lei.
Da, confirm. Aici
Yes, I
dacă îmi
confirm.
permit să
But
adaug
if
că
I may,
merge
I would
vorba
like
despre
to add,
același automobil
this is
care
the
mai
same
sus am
car
vorbit de
that we
240.000.
discussed before with
E același
240,000.
automobil.
It's the same car.
Yeah, no, that's correct, yeah. Please confirm that in 2016 you sold this car for the price at that time of 290,000 lei, so 50,000 more.
Da, confirm.
Yes, I confirm.
Yeah, and please confirm that you did pay taxes on the capital increase from the sale of this car in that year.
Eu nu pot să confirm am plătit sau nu.
I
El a fost
cannot
declarat toate sumele la organele
confirm
fiscale
whether I
și
paid or
cât
not.
a fost
All the
indicat
amounts were
de către
declared to the
organele
tax
fiscale,
authority,
celor
and
impozite eu am
as much
indicat
as the tax authorities
concret.
ask for me to pay, that's how much I paid. I cannot state precisely about this car.
But you did include in your tax declaration for that year, you did declare that you did sell
Da.
a car.
Da, sigur.
Yes, of course.
Yeah. Okay. But then please explain the difference between the market value of the car and the declared value, the market value of the car right now and the declared value in 2013. It seems that in 9 years difference, there is no price devaluation, and normally with cars that is the case. Can you clarify?
După câte am explicat
As
și
I
în întrebările
explained
primite,
in the questions that I
după câte
received,
mi-aduc aminte,
as far as I
automobilul dat
remember,
a mai
this
fost
car
instalate sistemul audio
got a new
sistem
audio
GPS, după câte
system,
mi-aduc
a new
aminte.
GPS system, as far as
Deci
I
el a fost
remember.
îmbunătățit
So it was
și când a
improved.
fost
And
realizat,
when I
s-a
sold it, The direct negotiation was based on the property that, well, the good that I was selling, based on what was also added to it. That's it.
Okay. Anything else you have to add to this declaration?
No, thank you.
Okay, thank you very much. That was it from my side. Then I pass on to Victoria Henley for follow-up questions. Thank you again.
Good afternoon, Mr. Bejenaru. I have some questions about potential conflicts of interest. On January 12, 2021, you were a member of a panel of judges at the Supreme Court of Justice that examined a case in which one party was represented by lawyer Doran Popovici. The case involved the collection of a debt and legal expenses sought by the client of lawyer Doran Popovici. By decision of January 12, 2021, the panel of judges of the Supreme Court of Justice, of which you were a member, maintained the decision of the first instance court by which lawyer Doran Popovici's client was to be paid the sum of €8,181 as debt and €7,469 as penalties, a decision in favor of the client of Doran Popovici. You participated in the case despite a long-standing friendship with Doran Popovici, who represented a party. Please confirm that you are friends with lawyer Doran Popovici.
With Dorin Popovici, we're colleagues. We work together. We worked together in Buyukan Court, and we had good relations, a good relationship.
Okay. And your friendship with Doran Popovici is a long-standing one, going back to when you were both judges at the Chisinau Court, where you were a judge from 1994 to 2008, and he became a judge in 2003. Is that correct?
Yes, that is correct.
Okay. Please confirm that your friendship with lawyer Doran Popovici has included traveling together, including trips together to Romania, sometimes including with your wives?
Yes. That was about 10 years ago.
Right. Between January 2nd, 2009 and January 8, 2009, you traveled by car with lawyer Doran Popovici and both of your wives to Romania. Is that correct?
Potentially, I do not refute this.
Can you confirm that between August 17, 2012 and August 29, 2012, you traveled by car with lawyer Doran Popovici and both of your wives to Romania, a trip for 12 days? Is that correct?
Yes.
Please confirm that between June 28 and July 3rd, 2013, you traveled by car to Romania with Doran Popovici and two other individuals?
Yes, I can't remember precisely the period when it happened, but yes.
Okay. Did you submit a request for recusal of yourself from the case in which Doran Popovici appeared in 2021 to the court for consideration?
Well, if I may, I would like to say that Popovici is not a lawyer. He is a representative of an enterprise. But at the Supreme Court, he did not participate. I had no way of knowing that he was a representative because I looked into the decision after I got the questions, and then I checked. And there were two enterprises involved in a case. There was an enterprise and an individual. And Dorin Popovici previously used to be the representative of that enterprise. Now, in the Supreme Court, the cases are reviewed without the parties, and I did not know that he was involved with that case. Therefore, I had no way of knowing of that and to thus recuse myself. At the Supreme Court of Justice, the cases are reviewed without the parties being present. So I couldn't know when the file arrived, the file is concerned, there are the parties to a file. But Popovich was not the lawyer, not the attorney. And at the Supreme Court of Justice, he was not the one. He was not the one to file an appeal. So I had no way of knowing that he had anything to do with that case, and thus I did not take any action.
So his name did not appear on any paperwork at the court in connection with the case?
No. I looked into the decision of the Supreme Court of Justice and I checked, and his surname did not appear anywhere. Maybe he did defend their interests in the first instance court, but I did not see his family name in any of the cases, in the case that I dealt with at the Supreme Court, to be able to recuse myself.
So you didn't review any of the paperwork from the first instance court?
I looked into the judgment, into the decision that was issued. However, the fact that he was the representative, I did not pay attention to that. I saw who were the parties to the case only. There was an enterprise and an individual, and Popovich did not appear there as party to that case for me to be able to notice that he was there. And in the appeal was not written by him either.
Well, asking you now about another case. On November 5, 2022, you were part of the panel of judges at the Supreme Court of Justice, which examined the appeal of a case in which one party was represented by lawyer Iurie Tocan. The case involved a request for privatization of a residential space and exclusion of Iurie Tocan's client from the list of participants in the privatization of the property. The first instance court and the Court of Appeal had partially admitted the request of the party who was opposing lawyer Iurie Tocan's client. By decision of November 5, 2022, the panel of the Supreme Court, of which you were a member, admitted the appeal of lawyer Iurie Tocan's client and sent the case for retrial. That decision changed the decision of the Court of Appeal in favor of the client of Iurie Tocan. You participated in the case despite a long-standing friendship with attorney Iurie Tocan. Please confirm that you are friends with lawyer Iurie Tocan.
We are not friends with Madam Iurie Tocan. We are simply acquaintances. A few years ago, we were together in Romania. We traveled together to Romania. I am rather more closer connected with her brother, but not with her precisely, and we don't have a long-standing relationship. We're not maintaining any friendship whatsoever or any other relationship of any kind.
And you are friends, however, with lawyer Iurie Tocan's husband and her brother, correct?
With a brother, mostly with a brother.
Okay, but when you traveled with attorney Doran Popovich in June and July of 2013 to Romania, lawyer Iurie Tocan's husband and brother were also with you on that trip. Isn't that correct?
I don't remember, but they were not with us specifically, not in our specific company.
But you traveled across the border in the same car, is that correct?
Potentially, but no, not in the same car. I don't think in the same car, but I can't remember now very well. I crossed the border in the same car years ago, several years ago, but I can't remember exactly when.
Okay, and between August 3rd and August 6th of 2012, you traveled by car with lawyer Iurie Tocan and both of your spouses to Romania, isn't that correct?
That is correct.
On December 30th, 2012, you again traveled by car with lawyer Iurie Tocan and both of your spouses to Romania. Is that correct?
Posibil, da.
Potentially, yes.
On November 5, 2022, you were part of a panel of judges at the Supreme Court of Justice which examined the appeal of a party represented by lawyer Iurie Tocan. Is that correct?
Da.
Yes.
And please confirm that the case involved a request for privatization of a residential space and exclusion of lawyer Iurie Tocan's client from the list of participants in privatization of the property.
Eu nu pot să-mi aduc aminte
I can't
anume
remember
litigiul,
now
dar
very well what that litigation
n-am
was
fost
about.
raportor eu,
I
am
was
fost
not
un membru
the judge rapporteur.
completului
I was a member
și
of the panel of judges.
completul a depistat careva
And the
încălcări
panel has
procedurale,
found
de ce
some
au fost,
procedural violations,
casate
and
deciziile și întoarse la
therefore the
rejudecare.
decision was quashed and was sent back for a
anume
trial.
care
I can't remember very well, very specifically what was the subject of that litigation.
Dar a fost întors la rejudecare
But
numai
it
din
went
careva
back to
proceduri
retrial
de
because there were some
procedurale.
procedural violations involved.
Okay. And did you submit a request for abstention on that matter to the court for consideration?
Nu am prezentat
I
cerere
did
de abținere,
not
deoarece
present such a
am considerat
request
că nu este
because I thought
niciun temei
there was no
relațiile mele cu
grounds in terms
Iurie
of
Tocan, că
my
să le-
relationship with Iurie
să le iau
Tocan.
careva
I did not
abținere.
believe that was grounds for me to abstain myself
N-am văzut anume temei la
at that
momentul
time. So
acela
at that moment in time, I did not find any grounds that would be an obstacle for me to participate in reviewing that case.
Please confirm that by the decision of November 5, 2022, the panel of the Supreme Court of Justice, which examined the case in which you were a member, admitted the appeal of Iurie Tocan's client and sent the case for retrial.
Da, consider.
Yes, I confirm.
And please confirm that we could consider that a decision in favor of the client of attorney Iurie Tocan, and that the Supreme Court changed the decision that had earlier been reached by the Court of Appeal that was not in favor of Iurie Tocan's client.
Dacă Curtea Supremă de Justiție
Well,
a
if the
ajuns la
Supreme
concluzia
Court of
că
Justice
necesar să
arrived at the
caseze
conclusion that it was
decizii din careva
necessary to
încălcări
quash the decision for
procedurale,
because of some procedural violations, then I believe that was a decision in the favor of the law, not in the favor of a particular party to a case. So I don't think that the fact it went back to a trial for procedural violations, I don't think that that is in favor of a particular lawyer or client.
But that was the relief that the client of Iurie Tocan had sought. Isn't that correct?
Posibil, dacă
Potentially,
depus recurs,
if
nu
they
mai țin minte
filed an
cauza
appeal, I
concret.
can't remember very well the cause that led to that.
Would you explain why you presided in the case despite your relationship with lawyer Iurie Tocan?
Am spus că
As I
la
said,
Curtea Supremă
the Supreme Court, the cases are reviewed in the absence of the parties concerned. Therefore, I did not think there was an obstacle that could have prevented me from participating in reviewing that case.
nu consider că
And I do
relațiile
not
mele
think
erau
that
în așa
my
măsură
relationship
că
was of such
îmi iau
nature
abținere
as
la
for
examinarea
me
cauzei.
to recuse myself and abstain from reviewing that case.
Do you believe that your relationship with lawyer Iurie Tocan could be a circumstance that might call into question your impartiality if you participate in cases in which she is representing a party?
Nu consider că este impediment.
I do not
deoarece,
think
cum
there
am
are any
spus, nu
impediments
sunt
because, as
relații
I
cele așa
said,
apropiate
my
ca eu
relationship
să-
with Tocan are not
pot să-mi-
that
să mă
close
abțin de la examinarea
to
cauzei.
make me abstain or recuse myself for reviewing a case. We are not relatives,
Pur și simplu cunoștințe
we're
care,
just acquaintances.
eu, conform legii, trebuie să
According
examinez
to
și
the law,
indiferent de care
I have to look into
obiecții
cases
care apar
regardless
în
of any
dosar, deci
objections that can
am considerat
appear
că
in a file, and
nu sunt
I
temei
thought there were
legale pentru
no
a mă
legal
abține
grounds for me to recuse myself from reviewing that case, especially that it was in the absence of the parties. The parties are not present there, and at the Supreme Court, we're only looking into legal matters, legal aspects, and if it has been quashed and went back to retrial, it means there were issues in that regard.
Is there anything else you'd like to add or further clarify with respect to your handlings of the matters involving Attorney Doran Popovic and Attorney Irina Tokan?
I would like to add that having reviewed after I received these questions, having looked into it, I think these were the only cases where I participated, and I can't remember of any other cases where these people would have been in any way parties to a case reviewed and where I would have been involved as well. But as regards Popovic, he is changing jobs. I mean, he's moving from one enterprise to another, so I don't know where exactly he works and which one exactly he represents. And if it's not put down in the file, then I cannot see it and see this as grounds for me to recuse myself.
Thank you.
Thank you very much. Are there any of our other colleagues who would like to ask a question? Yes, Nadesha, go ahead.
Greetings, Mr. Bejenaru. I would like to ask you to clarify a situation when you explained that in the case that you looked into, that we reviewed, where there was a representative of one of the parties, that is, Popovic was the representative of one of the parties. You said that this information cannot be seen in the file, that you don't see it. But in the integrated case file management system, this information is visible. You can see it right away. Can you explain us the judges, for the judges at the Supreme Court of Justice, when the files are distributed, doesn't every judge examine or look into who are the people involved, particularly in order to recuse themselves, in order to avoid any conflict of interest whatsoever? I'd like to say that this file where Mr. Popovic was involved was not distributed to me, and for that reason, I looked into it specifically. I did not look into it specifically in the program because it was not distributed to me. But when we reviewed the file during the reporting on that case, you couldn't see exactly the surname of Popovic. It didn't appear there. That was the enterprise that was concerned. It didn't say this enterprise represented by this person. If it said represented by Popovic, I would have seen that name and I would have raised this issue. But it was only the individual and the enterprise. So just for us to have a better understanding, if the judge from the Court of Justice, Supreme Court of Justice, is not the rapporteur, it means that the judge reviews the cause only on the basis, the case only on the basis of the report presented by the reporting judge, and they do not look at the other files and the other documentation. No, you asked about whether we looked into the program, into the IT system, whether we see who are the parties. But every judge can check in that particular program and pick the file that that was attributed to them. But when we have the discussion, the reporting meeting, yes, there's the judge rapporteur who makes a presentation, and then each of us has the opportunity to look into the file if we think there's any such need to do so. If there's some information that we don't know and that we need to have a look at. And the last question, so to you, are you stating that in the decisions and in other procedural documentation from the first instance and the Court of Appeal, are you saying that nowhere did it say that that company was represented by this person? I can't confirm now. I don't remember very well, as in it was it indicated nowhere at all. When I looked at it, I did not pay attention to this specific thing as to who is the representative of a particular enterprise. I just looked at the parties to a case, and then I drew the conclusion on the basis of that. Thank you.
Yep, Vitaly, go ahead.
Domnule Bejenaru,
Mr. Bejenaru, just in order to clarify the situation, I would like to ask a follow-up question with regards to the land plot in Durlești. You were asked today, too, about why you filed an application for improving housing conditions to Durlești City Council. And you said that you were acting judge in Buiucani Court from Chișinău, and you said that you received from the prefect a letter guiding you to file such an application with the Durlești local authorities. Considering that right next to Buiucani, there are several suburbs adjacent to it, but what made you file an application in Durlești specifically? As I said, this was suggested by the local authorities, was suggested to me by the local authorities, and they said they did not have any apartments to distribute, so they said, try to do it in Durlești. Maybe they would approve of an appropriation of an asset to you. So this was a suggestion that came from local authorities. They told me that Durlești City Hall is part of Chișinău municipality and that it's part of Buiucani City District, and that they said you should try to file an application there. But did you understand the reasoning behind that suggestion? Because Trușeni too is close to Chișinău, it's adjacent to Chișinău. Why did you go for Durlești? I don't know, we decided back then to just apply for it in Durlești. Okay, I got your answer, but one more additional question that has to do with vehicles. This was previously discussed today. When you were asked whether you paid the capital gain tax, you said you paid all the taxes as they were accrued, calculated by the tax service. And you mentioned that when the car was sold, you reported the sale and the amount. Can you confirm, or can you tell us, when you filed your tax return to the tax authorities in 2013, what was the amount that you put down there for the BMW fabrication year 2004? With the tax authorities, I put down the amount that was also taken from the sales and purchase agreement. I couldn't have put down any other amount. And what was it? I can't remember now. In 2013, did you say? Yes. Well, 2013, with the tax authorities, there were two amounts, 150 for one car that I sold, and 240 for another one that I purchased. Or did you mean when I sold the car? You said that there was a 2013 tax return. What is the amount that you reported to the tax authorities as the contractual value provided for in the contract for these vehicles? I can't remember precisely, but it was the same amount that was in the sales and purchase agreements. It was that amount. Whatever was there was also reported to the tax authorities. Mr. Chairperson, no more questions from me.
Okay, thank you very much. Then I would like now to give you the opportunity to make a brief closing comment at the end of this hearing. Of course, only if you would like to do so, then you have the opportunity now.
I would like to thank the Commission for this hearing. I would like to say that I feel certain that the activity, the complex activity of the Evaluation Commission will meet the expectations of the citizens with regards to the efficiency of the justice sector reform. I hope that my answers will contribute to shedding light on the matters raised by the members of the Commission, and I count a lot on the impartiality, objectivity of the members of the Commission. Thank you.
Thank you very much. Hereby we come to the end of the hearing. I thank you, Mr. Bejenaru, for answering all the questions that the Commission had. As per usual, the Commission will now withdraw for deliberation, and a recent decision will be delivered later. As much as possible, the Commission will strive at delivering the decision within a month from the date of the hearing today. I hereby declare this hearing closed, and thank you again.